Good morning, everyone. I'm Patricia Linggen from BSBA Marketing 1C. I'm the first reporter of Group 8. So, our topic for today is about QUASI-DELICT or contracts and other transactions. First, we should talk about what is QUASI-DELICT or contracts. So, QUASI-DELICT or contract is a retroactive arrangement between two parties who have no previous obligations to one another. It is created by a judge to correct a circumstance in which one party acquires something at the expense of the other. So, I have the example here. If a person ordered a pizza online by providing his address and paid for the same time, at the time of the delivery of the pizza, the deliveryman delivers it to the wrong address. The receiving party, instead of denying the delivery, accepts the order and consumes the same. So this is why we call it QUASI-DELICT or contract, because instead of denying that it was not theirs, but they still receive the item. So, the second topic is ethical consideration. There are also some acts which cause damage to another, but not considered crimes, simply because the law does not declare it to be, and or because the proper authority, for whatever reason, did not or failed to file the necessary criminal complaint. The Civil Code, RA 386, and pertinent laws have declared them civilly actionable for damages. So, ethical consideration, it is like a system to just ignore a crime or as if the crime did not happen because it is not in the law, or maybe you didn't file a complaint against to the opponent. So, this system have also the Civil Code RA 386 and pertinent laws have declared them civilly actionable for damages. So this civil code is a way that what happens to both parties is like they will be fair to what happened to them. QUASI-DELICT. Whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a QUASI-DELICT. Article 2176 Civil Code. Responsibility caused by QUASI-DELICT is entirely separate and distinct from the civil liability arising from negligence under the Penal Code, but the plaintiff cannot recover damages twice for the same act or omission of the defendant. Article 2177 Civil Code. So, the explanation is, QUASI-DELICT is used in civil law to refer to a negligent act or omission which results in harm or damage to an individual or the property of another. The person causing harm or damage may do so without any malice, but may nonetheless be found at fault as a result of being negligent and or imprudent. This exposes the individual to civil liability in the same way of if the act or omission was intentional. So these are QUASI-DELICT article and civil code if ever you cause some accident. So in this topic, it talks about the liabilities of parents, guardians, state, establishments. Parental liability is a term used to refer to a parent's obligation to pay for damage caused by negligent, intentional, or criminal acts committed by the parent's child. A parent's liability usually ends when the child reaches the age of majority and does not begin until the child reaches 8 to 10 years old. Today, most states have laws relating to parental liability in various applications. So, the explanation is parents are liable for the acts or omission of their minor child living in their company, but the liability will cease when the father or mother has proved that they followed all the efforts of being a good parent of the family to avoid injury. These are the article and civil code for parental liabilities. The responsibility treated in this article shall cease when the persons herein mentioned prove that they observe all the diligence of a good father of a family to prevent damage. Article 2180 Civil Code. If the minor or insane person causing damage has no parents or guardians, the minor or insane person shall be answerable with his own property in an action against him, where a guardian ad litem shall be appointed. Article 2182 Civil Code. The possessor of an animal or whoever may make use of the same is responsible for the damage which it may cause. Although it may escape or be lost, the responsibility shall cease only in case the damage should come from force majeure or from the fault of the person who has suffered damage. Article 2183. So the next topic is about motor vehicle mishap. In motor vehicle mishaps, the owner is solidarily liable with the driver. If the former, who was in the vehicle, could have, by the use of due diligence, prevented the misfortune, it is disputably presumed that the driver was negligent. If he had been found guilty of reckless driving or violations of traffic regulations at least twice within the next two preceding 2 months. So, if you are involved in a motor vehicle accident, you must obtain the other party's contact, and insurance information. You should also delete the contact information of any witness to the accident and provide this information to your attorney or insurance company. People involved in the accident will file claims with their car insurance companies, which will review the police report and make a preliminary determination of guilt, depending on your state's auto insurance laws and who he is at fault. The car insurance company may reimburse some of the cost of repairing or replacing the vehicle. This is the civil code of motor vehicle mishap. If the owner was not in the vehicle, Article 2180 applies. Article 2184 Civil Code, a motor vehicle mishap means vehicular accidents. Unless there is proof to the contrary, it is presumed that a person driving a motor vehicle has been negligent if at the time of the mishap he was violating any traffic regulation. Article 2185 Civil Code. If the owner was not the driver, the owner shall be responsible as an employer. Article 2180 Civil Code. That's all. Thank you.